do you do? The light you plan to shatter. What do you say? The one you love is gone. How do you live? Seems like no hope for tomorrow. It doesn't care where you live or who you are. See, my life is broken. I don't know what to do. When I can't see, I know. Whoa, when I cry out.
I create.
I'm praying for healing. Where do you call when no one has the answer? Where do you go? The place you've known is no more. When will they stop? All the tears, they just keep falling. Pain doesn't care where you live or who you are.
I don't know what to do. I will count on you well. I know you're praying. We're praying for healing. It's time to mend.
Put your hand together and say it. Hold on. Say it. Hold on. Say it. Just a little while. Say it. New York City, did you hear me? Say it. 'Cause we
Oh, 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 oh.
We're here again.
Greetings, 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 greetings. I am King Clifford Jefferson, ascendant and descendant of Godfrey, the fifth Canavan Jew, the son of folk, the ruler of Jerusalem. I'm the reincarnation or the incarnation or the personification or the incorporation of our King, King Edgar, the King of Peace, the Vicar of Christ, Melchizedek, or the King of Righteousness, and his present day, which you call 2026, which is equivalent to the birth year 2976. I greet you in the name of all of you, in regards to who you truly are. You are the ancient Berbers. Today is part 2 of your understanding in regards to restitution, reparation, or compensation for the taking of your land, not just your land, but you as property under the so-called eminent domain power of the states, which is now called the United States. Prior to that, they were called the United Colonies. Prior to that, they were under the jurisdiction of the proprietors. Prior to that, it was a time when they did not know because it was ran by what we call the British Parliament. And we know the British Parliament pretty much functioned under feudal law that operated from 1066 all the way up into the year 1664 under, underneath under the titles under what we call the Lords Proprietors. Okay, so this is part 2: restitution, reparation, or compensation for the taking of your land as well as you as being property through the eminent domain power of the states, which is what they call their sovereign power. Okay, their sovereign power to take under the Fifth Amendment. I just want to give honor to you, all of you today, who has been studious to my lectures. I know that there's a lot of platforms out there that claim to teach the truth. Okay, and I'm not saying that there is not some truth to what they say, but what I am saying is that that truth has no interest in regards to the capacity involving property. Okay, the land or you. Okay, so the main two things that we need to concentrate on today's lecture in regard to property. Okay, yourself and your inheritance. Okay, it's interest and capacity. Interest and capacity. Define those words and apply those words to yourself. Okay? Your interest and capacity. If you don't have an interest, you don't have a capacity. If you don't have the capacity, then you don't have an interest. If you do have the capacity, you do have the interest. We must understand those two terms from a lawful perspective, not a historical perspective, philosophical perspective, or any other perspective that one can think of. Okay, this is all dealing with law. Okay, how the law denotes to your interest and your capacity involving property. Okay, whether you're talking about yourself or whether you're talking about land, because you are the inheritors of the land. This is key. So if any one of you who are listening today who would want a one-on-one, please leave me a comment in the comment box, as well as who would like sound step-by-step um, uh, remedies in regards to injunctive relief that you can receive in a court of law in present day, please reach out to me. Okay, for a small donation, or a small gift, I'm willing to extend my free time to you. Okay, so with that, let's get started with part 2: restitution, reparation, or compensation for the taking of our land through the eminent domain power. Okay, very important that you pay attention. All right, pay attention. I'm going to go very slow. Once again, those who are serious about their inheritance, okay, as well as those who have platforms out there, okay, that would like these teachings to be a part of their curriculum, okay, I'm open for invitations, so please leave a comment in the comment box, like, share, subscribe, as well as donate if you can, all right, to the upliftment of the heirs and successors of the English Empire within what we call North America. All right, so with that, let's get started with this marvelous lecture. I didn't go to school for none of this. I didn't go to college. Okay, everything that I'm teaching here was self-learned, was self-taught. Okay, So it's very important to understand that I'm human just like you, but no human has put together such information that can be applicable in regard to your interest and capacity involving the land and you. Okay? So with that, let's get started. We're going to go over a couple of terms first. Most of you, when you seek relief, it's based upon restitution, reparations, or compensation for somebody that you claim did you wrong. Okay? Whether it's individual, collective, all right? And if you are of what we call of a darker complexion, for the lack of a better term, i.e., colored, dark, black, and any other synonymous term, then this lesson will apply to you as well. Okay? And we all want declaratory relief. Okay? Before we can get injunctive relief, we need declaratory relief. Okay? Not in the forms that we usually are part of, all right, but in the proper form, all right, the proper form that has the proper jurisdiction. Okay? 1 second, hold that thought. Sorry about that. So let's look at declaratory relief first. Okay? What is declaratory relief? Especially in regards to restitution, reparation, and compensation for the taking of you as property in your land. Okay? We need the courts to make a determination in regards to whatever evidence or proof that you claim. All right? In regards to the restitution, reparation, or compensation for the taking of you as property, all right, or as well as the taking of your land. This is what needs to be understood. Okay? Because a whole lot of talking without a proper understanding is for naught. Okay? This is why I do these lessons. This is exactly why I do these lessons. Let's share. Okay. Declaratory relief. Declaratory relief refers to a court's declaratory judgment. Okay? Listen very closely. This is what you want. If you're on platforms and you're not talking about seeking declaratory relief in lieu of injunctive relief, all right, which is much, 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 much better than some type of restitution, reparation, or compensation which is for some so-called thing that they call money, which is not money if it's not gold and silver. Okay, so it's very important to understand that when you want declaratory relief, okay, remedy, reparations, compensation is what we call a declaratory relief. Okay, declaratory relief refers to a court's, not Congress, okay, not the president, not the governor, but the courts. Declaratory relief refers to a court's declaratory judgment stating the rights of parties without ordering any specific actions or listing awards for damages. See, most majority, this is what you want. You want damages, but the only damage you think about is monetary damages, okay? You don't ask for property. You don't ask for land. You don't ask for real estate because that's not the proper form to receive these type of compensations, which you call relief, okay? You need a court, a law for this type of relief, i.e. declaratory relief. Declaratory relief allows a party who is not certain of his rights to prevent the accrual of avoidable damages and to obtain an adjudication before the parties bringing a coercive lawsuit. You hear that? Brings a coercive lawsuit. So declaratory relief allows a party who is not certain of his rights to prevent the accrual of avoidable damages and to obtain an adjudication before the parties brings a coercive lawsuit. Declaratory relief can be contrasted with coercive relief, where the courts order a party to pay monetary damages or take certain actions under injunctive relief. Okay, so we just define declaratory relief. What is injunctive relief? Let's define that real quick. Now, this is what you want to be talking about on your platforms. If you got one, please send me an invite, and I'm definitely open because this is not just for me, it's for you. Injunctive relief. Injunctive relief, also known as an injunction. We know what injunction means, right? We know what injunction means, right? Injunction means to prevent, to prohibit, okay? To stop, all right? Injunctive relief, also known as an injunction, is a court order remedy which restricts a party from committing specific actions or requires a party to complete specific actions. Generally, injunctive relief is only available when there is no other adequate remedy available, and irreparable harm will result if the relief is not granted. Okay? This is what we want. Declaratory and injunctive relief. So if any of your leaders cannot give you this, then that's not where you should be looking for in regards to due process of law. All right? Everyone understands that? Let's go here. Where do I want to go with this? Let's go back to where we started. Let's go here. So we know the title of this lecture is Restitution, Reparation, or Compensation for the Taking of Our Land under what they call the States or the United States or the American government eminent domain power, i.e. very important. So what is the eminent domain power? Okay, what is that? Because this is what we suffer from. And this is nothing more than a recap. Write this down. Eminent domain also known as land acquisition. Okay? We existed on the land. All right? We were already on the land. We didn't converse or traverse, all right, to this land. We were already on the land. It was our homeland. It was our a land that now became an estate of inheritance based upon what preceded our existence. Okay? This is based upon your ancestry. Okay? Okay? Based upon your nationality, your affiliation with your nation. This is, i.e., synonymous with what we call genealogy. Okay? Ethnicity. Okay? And not some aberration of a title. Okay? Such as color, black, okay? Negroid. Eminent domain, also known as land acquisition, or compulsory purchase, resumption or compulsory acquisition, or just expropriation, is the compulsory acquisition of private property for public use. Meaning the taking of private property for public use, the taking of somebody else's property that's private for public use. It does not include the power to take and transfer the ownership of the private property from one property owner to another private property owner without valid public purpose. So it does not include the power to take and transfer ownership of a private property from one property owner to another. Property rights. Let me read that again. It does not include the power to take and transfer ownership of private property from one property owner to another private property owner without valid public purpose. This power can be legislatively delegated by the state to municipalities, government subdivisions, or even to private persons or corporations which they are authorized to exercise the functions of public character. This is called capacity. Okay? This is called their capacity and their interest to take private property for public use. Who gave them that capacity to have an interest in taking private property for public use? Okay? This is what we need to understand. By the time we end this lecture, you will. Hold on. Okay, let's see. So I hope you wrote all these terms down. Okay? I hope you wrote them down. Let's go here. Let's start here. A picture speaks 1,000 words. Remember, I talked about interest and capacity. Interest and capacity. If you don't have any capacity, you do not have any interest, especially in regards to property, whether it's yourself, an estate in land, i.e. real property, or just land itself. Okay? So very important to understand modernly how applying your so-called interest that you claim to have in land or property or just yourselves, all right, denotes to the capacity of who gave you that interest to have an interest in land or property such as yourself, okay? Because it's not just your mother and your father. They themselves got that interest and capacity in regards to whatever they have in their possession from something else, okay? Notice I said something else. not someone else, something else. Okay? Something. Two words. Something. What is this thing? What is this entity? All right? That we have an interest in regard to that capacity that we inherited. Okay? The only avenue we can look at for that is law, because we want declaratory and injunctive relief, because we know the only person that can hear a matter such as this argument is the courts. Why? Because the courts have what? Jurisdiction. Okay? Jurisdiction. What does jurisdiction mean? Jurisdiction, from Latin juris, law, and dicio, speech or declaration, is the legal term for the legal authority. Hence that word authority. Okay? That's capacity. Okay? Authority means capacity. All right? Legal standing. All right? So jurisdiction is a legal term for the legal authority held by a legal entity. Hence the word entity. Did it say person? No. It said entity. All right? Also, it says jurisdiction is the legal term for legal authority held by a legal entity. Write that word down. To enact justice. Jurisdiction is rarely claimed to be complete. Rather, it is limited, for examples, by geography, subject matter, or other factors. Okay? It is only within the scope, inside the limit, i.e., within your what we call capacity. Okay? Within your capacity. Did not be within your capacity is is what we call out not within the limits of your authority. Okay? Or not within the scope of your authority, which we consider in the eyes of law what we call ultra vires, okay, which is ground for declaratory injunctive relief. It is only within the scope, inside the limits of such jurisdiction, that, for example, the parties to a dispute have standing to bring a matter, i.e., a legal question, before a judge who has the power or jurisdiction to decide its authoritatively, authoritatively, pardon yourself, authoritatively, if I'm pronouncing that right, authoritatively. All right. So the judge or the court of law is the only jurisdiction that has the ability to be able to clear what is the law. Okay. What is the meaning of the law? Okay. What is the length of the law? Very important to understand jurisdiction. Okay. Very important. A jurisdiction can also be understood as a category name for any separate polity, i.e., corporate body of politics, legally constituted, i.e., legally incorporated as such, for any government with legislative or other legal power over a particular territory, whether that area is a nation state or some smaller region. Okay? Very important to understand the term or the word or the legal phrase jurisdiction. Okay? Now we got that out of the way. Let's go back. Let's repeat. Take a good look at this AI generated uh, flow chart. This is where we get our capacity from. We know capacity means authority, divine authority. This is God's grace because we're within His what? Jurisdiction. Okay? We are within its God's jurisdiction. I'm going to prove it to you. Hold that thought. Okay. So we have the capacity, and the capacity that we inherited is divine. All right, because we know that this divine authority, which gave us our capacity, came from us being within the jurisdiction of where the authority, which is divine, came from. Okay, and the highest authority which it can come from to us is God. Okay, all right, and by us understanding this today, okay, it gives us the ability to become what we call a jurisdictional person by giving us a jurisdictional personality, okay, which makes the jurisdictional person a lawful vessel by way of baptism, okay? Being baptized by the holy water by understanding that you are, in fact, a living vessel, okay? A living vessel that must be made a lawful vessel to be within God's jurisdiction and to be under God's grace, to be under God's divine authority, which is that capacity, okay, that interest and that capacity, which was once under what we call canon law or ecclesiastical law, okay, which we call our spiritual law, okay, either it's called canon law, ecclesiastical law, and we know when we talk about canon law or ecclesiastical law, this is where the separation comes in from our understanding, because we know that our particular church was governed by English ecclesiastical and canon law. We understand that this came through the English Reformation of the Benedictine monasteries in the 9th century, okay, which came to its height by King Edgar the Peaceful, the one I'm personifying in this present day. Okay? He secularized through a process of decentralization our ancient, what we call customary assemblies that were more focused with liberty. Okay? Liberty, freedom. Okay? Not just some spiritual or religious belief. Okay, so it's very important to understand, especially in the 18th or 19th century, how these doctrines apply at that time. Okay, so we see that the canon law or ecclesiastical law, which is religious law, has now been decentralized by way of it becoming secularized. This gives you the interest and the capacity because the law that was governed under God's law, which was spiritual, based upon belief, has now been decentralized and secularized under the common law, which we now call modern law, by way of statutory interpretation. Okay? All right? So we understand that canon law or ecclesiastical law, whatever you call it, has been modernized to what we call American statutory law. This is what makes you a statutory entity. All right? It makes you a statutory entity. Everyone asking yourself, well, how? How does that make us a statutory entity? Let's see. You call it a corporation, so. Let's see. I mean, part yourself. You don't call it a corporation soul. You call it a straw man. Okay? We call it a corporation soul. All right? You call it a straw man, a fictitious person. All right? But we understand that straw men or fictitious persons are nothing more than what we call legal fictions, which have some rights at law because they are considered what they call corporate entities. All right. So when we read our existence in modern day as a corporate entity, we see the switch from religious canon law, which we call English law or common law, now decentralized or secularized into what we call modern day law. When you look at New Jersey statute annotated 16:1-28, this statute reads based upon the plain language of the statute, okay? Based upon the plain meaning of the statute, all right, not looking into the statute historically or based upon some saying, just say historically, okay? When you read the statute, it should not be applied based upon an historical standpoint, all right? And claiming that the language in the statute is outdated or has no effect other than the historical application. Because if that was in fact the case, then the legislator who created the statute would have said so. Okay? And any judge try to tell you otherwise is appealing or repealing what the legislative has not deemed so. Because if the legislature deemed to be just to have a what we call historical effect and it's considered to be outdated but and have no validity in modern day, it would have said so. Okay? So you must understand that when we go into these courts of law, we must not let them make law from the bench. All right? Because they are not the legislator. All right? We understand the legislator preserve our interests and capacity in regards to our rights and property. Not just ourselves, but the inheritance that was inherited from our posterity. Okay? And we understand that the capacity and interests are not the same. All right. So we got our capacity. What is our capacity as being a part of a corporation soul? A corporation soul is a natural person, all right, holding the office of a entity, all right, and the object or the legal standing of that natural person sitting in that office is based upon that mission. The mission statement. The mission statement is the continuity of possession. Okay? Through continuity of office. Whatever office there is only there for the continuity, for the continuance, all right? For the posterity, all right, of the property. That includes you, all right? So we see under 16:1-28, this statute says, rights saved under the charters of Great Britain, saved from repeal, meaning that you can't change it. An act to incorporate trustees of religious societies for property held in corporations in place thereof. So we talk about entities having an interest in property but don't have the capacity in that property because how they inherited that so-called interest, all right? And it wasn't from 16:1-28, all right? We understand that Title 46 in New Jersey governs property interest. It does not establish capacity, okay? Capacity comes from somewhere else. So our capacity comes from 16:1-28 as an entity. But we're not talking about entities, are we? We're talking about natural people, right? You're a natural person, aren't you? If you're a natural person, then you were born with the capacity. You just lack the knowledge of the interest and the capacity where your rights come from in regards to property, all right? So we understand Title 46 is the statute or the language governing interest and property, okay? Title 46 records interest and property, all right? It gives constructive notice to the world in regards to your interest in property and that interest that runs with the land, but it does not establish capacity, okay? That capacity comes from that somewhere else, Okay? So when we see that capacity that comes from somewhere else and lieu of that interest, it must be based upon the authority that has the authority, the capacity to grant it. That was God. Okay, so we see God's voice or God's language speaking through the statue. When we see the language speaking through the statue, that gave you your authority. That's the living water. Okay, that is the actual baptism. Okay, when you understand what I'm telling you, this starts the transformation until you're moving from a secular entity, i.e., a worldly entity, into what we call a spiritual entity, a statutory entity. Not that you're a natural person, but as a natural person, you're still protected by the natural law. Okay? But natural law, the statute. All right? So you don't need to be incorporated uh, to inherit your capacity and the interest that runs with the land under Title 46 or under any other title under any other states of any state of the United States, which were at one time called colonies. All right, very important for you to understand this lane I'm in. Let's go slowly. If your authority exceeds the capacity, if your authority exceeds your capacity, it becomes ultravirus and is void in the eyes of the law. Okay? Very important to understand that the interest and capacity that you inherited as natural people, because you're not corporations. You are natural people, so you would not fall under a ultravirus review before the courts. If you understand your capacity, because you are a statutory entity, okay, which has been baptized by way of now cleaning your vessel, because we understand that the vessel is nothing more than the corporation soul, which mission, i.e., that living water, okay? The statutory corporation is the vessel. The living water is the mission, which is the continuity of possession of property, keeping it within the family. This is what we call our ancient customary law. Okay? Our ancient customary law. The law of freedom. Okay? The law of freedom. Because we had the interest in the capacity. We have the right to preserve the interest in the capacity that runs with the land. We lost that. You will find out how today. Let's continue. To not be within this gold dome will be, in the eyes of the law, lacking the capacity. Okay? You lack the capacity, so you're not under God's protection. God's protection are the courts of law. In regards to you being his property, if you want to be somebody's property, you are God's property. All right? First. All right? You are God's property first. All right? Very important. When you were slaves, as you see here, you were still protected. You just didn't have the interest in the inherited because you lacked the capacity. You lacked the legal standing because you had no understanding of property law. Okay? That's why you were not allowed to read or write. Okay? Very important to understand why I did not want you to read or write. I'm about to show you why. For us to be free people again, we must come back under God's protection. All right? We must come back under God's protection. that shield. Okay? This shield is called the golden rule. Okay? The golden rule, or what we call the plain meaning rule. Okay, the golden rule or the plain meaning rule. Okay, this is what we went by in the golden age because we understood our capacity and interest that runs with the land. Okay, very important. Wakanda had a shield. Okay, very important to comprehend that. The shield has been broken, all right, which allows for invaders to come in and practice what they call eminent domain. Eminent domain. They're taking of you, your property, and claim to be compensating you, giving you reparations or restitution, but we have not received any. Why? Because they still got the same eminent domain statutes on the books today. Okay? We're very important to understand that. That's why you need to get me on these platforms to teach you correctly. This is why we reference the 1911 Encyclopedia Britannica. This is why we do that. Why do we reference the 1911 Encyclopedia Britannica? Why? Let's see why. When we quote the Encyclopedia Britannica, we're not quoting it because it's a modern encyclopedia. We're only quoting it because it denotes to what was happening at that particular time in the 19th century. What the 1911 edition was actually writing was, one second, hold that thought. I apologize. I'm talking and I didn't realize I had it on. I had the mic uh, on what we call. Uh, I had the mic off. I apologize for that. So let me just recap real quick. I apologize for that. Excuse me. So once again, we're talking about the 1911 Encyclopedia Britannica, and the 1911 Encyclopedia Britannica was written at the time of European imperial expansion. All right, at this time, there was a height of racial classification theories, and as well as colonial governance of North Africa, which, based upon historical references to us as a people, they claim we came from North Africa. And now we realize that when we read the 1911 Encyclopedia Britannica, this book was written in Edinburgh, Scotland, before it came here to North America. All right, and we understand that uh, this book came around the time of what we call the Scottish Enlightenment, meaning that this is a time where science became prevalent. Okay, so when you read in the 1911 Encyclopedia Britannica, this book was written based upon European imperial expansions that came about at the height of racial classification theories. Okay, hence racial classifications. Okay, as well as at the time where colonial governance of North Africa were at its height. Okay, and it was also a time when anthropology was based upon mixed politics, race, and history. Okay, so we must take these 4 points into consideration in regards to what we read in the 1911 Encyclopedia Britannica involving the connection that we have with Berbers and Anglo-Saxons. Okay, and when we say Berbers and Anglo-Saxons, we're not talking about the history that's told by those historians who lack the true understanding of Berbers who are identified with Anglo-Saxons. Okay, very important to comprehend that. Let's move forward. So it says, why compare Berbers with Anglo-Saxons? All right. The reason why they compare Berbers with Anglo-Saxons because they had a ancient system of customary unwritten laws that dealt with liberty. Okay, that dealt with liberty, freedom. Okay, this is the same thing that we as our people seek for today, which we have not received yet. We want freedom. All right. So when we look at the different societies or ethnicities or races, we have four classifications: Arabs, Berbers, Anglo-Saxons, and Germanic tribes. They said the Germanic tribes were actually the Anglo-Saxon tribes, but we, based upon what we read in the 1911 Encyclopedia Britannica, I find that hard to believe. Why? Because based upon the traditions and customs of the so-called Germanic people who came to be Anglo-Saxon and the Berbers and the Anglo-Saxons, which are identified based upon what they say in this 1911 Encyclopedia Britannica, that they had the same ancient liberties and traditions. Okay, they had the same ancient liberties and traditions, which were called folk right. Let's see. What the scholars or historians are building based upon the 1911 Encyclopedia Britannica, they are arguing that Berbers, like the Anglo-Saxons, were governed by what? Customs, a council, local autonomy, and unwritten law. This is what the British used to self-identify themselves in regard to their liberation from what we call the monarchs of Scotland. Okay? Very important. The British self-identified as Liberty Tradition Nations. They got this from the English people, which are in fact the Berbers. Okay? They are in fact the Berbers. We must understand that. Why? Because by the time I finish this lesson, you have no other choice. All right? So it says that this is a romantic projection, not a literal history. British scholars often try to show that liberty is not uniquely English. It appears among other ancient peoples. So not just the ancient people were seeking for liberty, i.e. freedom. The English were too. All right? So they portrayed Berber's customary codes which which were called the Qanun, all right, which was the same as protecting individual rights, limited rulers, and based on a community assembly. Okay, that this mirrored how Anglo-Saxon viewed how they practiced law based upon their customary traditions. All right, we understand Anglo-Saxon law was called folk right. Folk right was called bookland. Bookland was when it was written down, and folk right, which means when it was unwritten. All this type of interest and capacity in regards to land was well known way before what we call the Norman conquest, which brought in what we call feudalism. Okay? We must understand our capacity. All right, let's go here. Another 5 minutes on this and I'll move forward. All right here. All right. Understanding the medieval genealogical role. We call this the MS roll 1066. All right. This is very important to understand because it was based upon ancestry, genealogy. Okay, very important. That was preserved up into the present day. All right, very important to understand this. This MS roll or MS scroll 1066 is the medieval genealogical roll, which traces the lineage from Adam and Eve to the English kings. Okay, very important, to the English kings. Hold that thought. Okay. To understand that the MS scroll was just a record showing the link of the ancient ancestry from Adam and Eve to the medieval kings. All right, and the last king was Edward the Third. Okay, Edward the Third of the Plantagenet kings, which we are heirs, which is where we inherited our interest and our capacity to inherit the land. Okay, very important to understand that. All right, and I'm showing you. So the MS scroll was not a calendar, not used for historical dating. It did not arrange for sacred lineage. What it did was show legitimacy of the king, connect to biblical history and divine order and royal, hence that word, continuity. Royal continuity. Continuity of office. That is the mission. That is our mission, has always been our mission. Maintaining the continuity of office to maintain the continuity of possession of our ancestral estate, which was the land. Brothers and sisters. Why? Because Our main focus was the land. Okay? It was the land. Let's look at the structure of the role. All this is time out of mind, which we call time immemorial. From Adam and Eve, the fall, to the biblical patriarchs from Noah, Abraham, etc., to King David, to that Christ. I didn't say Jesus, I said Christ, because we know the word Christ means anointed. Okay? We understand that when we're looking at the word anointed, we call it personification or incarnation, all right, because we understand that through a corporation. So the natural person personified as the legal entity because of that what? Office, which represents continuity. We find this through all the English kings from Edward the First all the way to Edward the Third. Very, very, very important, especially if you're going to watch the ending of the remaining of this lesson. Okay? Very important. So the meaning symbol is not literal. Okay? The meaning is symbolic and not literal. Sacred history from creation to kinship. Legitimacy of the current monarch and divine providence and order. Very, very, very important for us to understand that. So here is a map of a chronological context. All right? We understand we have a religious, spiritual, okay? We have a religious, spiritual culture or custom, okay? Versus a liberty-based culture or custom, which is based upon an assembly, all right? So we're dealing with spiritual liberty and what we call natural liberty, okay? That can be actually utilized in a courts of law through what we call declaratory injunctive relief, because that brings forth what we call liberty, freedom. We don't want to hope for it. We want to actually see it. So when we look at the hope of freedom based upon time immemorial, going back to Adam and Eve, because they know they fell. Okay, if they fell, then of course they wanted freedom from their fall. Okay, this means to be uplifted. And how they were lifted by understanding their interest and capacity which they fell from. Okay? So this brings upon you understanding the religious, spiritual understanding, which I didn't say it has no applicability. What I'm arguing is that now needs to change to what we call a liberal um, uh, uh, forum to be able to express that in regards to the liberty and freedoms that you so-called express through your religion. Okay, for that you need to make the connection to your ancestors. Okay, we understand that our ancestors who preserved that interest and capacity in regards to the land were ancient kings. Okay, they were kings, and their mission was the continuity of land. All right, why was it land? It wasn't the office of religious and spiritual belief. It was the continuity of possession of the land. That's the only purpose that our king was here, to maintain the continuity of the land, because we understand that that was our inheritance. We see this preserved all the way from Anglo-Saxon kings, start with Alfred the Great, all the way up to what we call Edward the Third. They were all Berbers, because we know that the Berbers were affiliated with what? The land. Okay? The Berbers were agriculturists. Their main objective was preservation of traditions and customs that maintain the land. Okay? Very important to understand that. Then we understand that we have the feudal calendar, which brought in the time when the eminent domain power, which we call today, which at that time when William the Conqueror brought it, was called feudal law. The taking of the land, not the upkeep of the land, but the taking of the land for those who were upkeeping the land, and those were those who were our ancestors who preserved that interest and capacity that I've been talking about all morning. Okay, let's continue. And I'm letting the pictures speak to you. One more picture. right? So we understand that there was a liberty-based system based upon an assembly, okay? An assembly, what we call a liberty-based assembly that dealt with liberty, freedom, okay? And not a system that based upon spiritual and religious traditions and customs, all right? Now we have both. The dominant one we see is what we call religious and spiritual customs and traditions that we see practiced around the world. We don't see anything dealing with the assembly maintaining liberty and freedom from those who are affiliated with the spiritual and religious customs and traditions. Because this was the promise from God, okay, based upon the inheritance. So we have not made that connection. If you have not made that connection, then you lack the interest and capacity to having any claim in some so-called promised land. Okay? Promised land. Let's see why. It goes back to this eminent domain power. It goes right back to this eminent domain power. Let's look at this real quick. All right? Let's look at it. And we can blame Walter Plecker for that. Walter Plecker. How many of you know who Walter Plecker is? How many of you know who Walter Plecker is? We understand that. One second. Sorry about that. Okay. All right. So we're talking about restitution reparations or compensation for the taking of our land. All right, under the eminent domain power. This is part two of this. All right. Now we understand what eminent domain is, right? We heard what it said. Most of this that went right over people's head. Went right over people's head. One second, let me show you again. Now, what's the harm in this? Eminent domain is also called nationalization. You see it up there? For other uses, eminent domain and nationalization. How do you know what nationalization means? How many of you know what that means? Let's look at it real quick before we move forward. Nationalization or nationalization in British English is the process of transforming privately owned assets into public assets by bringing them under the public ownership of a national government or a state. Did you hear that, brothers and sisters? You can't get no clearer than this. Nationalization or nationalization is a British English in British English. You hear that? British English, not English, but British English. Okay, it's the process of transforming privately owned assets into public assets by bringing them under the public ownership of a national government or a state. Nationalization contrasts with privatization and with demutualization. Okay, so we understand what nationalization, which is the taking private property for public use without compensation. Okay, which is an asset. Okay, an asset. Very important. We know what assets are, right? All right. All right. So let's go back here. Let's look at the harm. Walter Ashley Plecker was an American physician and public health advocate who was the first registrar of Virginia, a Bureau of Vital Statistics, serving from 1912 to 1946. Now, we just read about the 1911 Encyclopedia Britannica. All right, we just read about that, and we read about the comparison they made between the Berbers and the Anglo-Saxons based upon their traditions or customs that dealt with liberty-based systems and not a spiritual, a religious-based system. Very important, and it all dealt with the continuity and possession of what? Land. Okay? Very important. So we're reading the understanding at the time of Walter Plecker in regards to not ethnicity, nationality, because they were only concerned with an aberration of identity, all right, which is based upon the color of a skin. All right, very important. So Walter Ashley Plecker was an American physician and public health advocate who was the first registrar of Virginia Bureaus of Vital Statistics, serving from 1912 to 1946. He was the leader of the Anglo-Saxon Clubs of America, a white supremacist organization founded in Richmond, Virginia in 1922. So now we both see that they said he was a part of the Anglo-Saxon Club of America, but he was a white supremacist. All right? Very important. Plecker drafted and lobbied for the passage of the Racial Integrity Act of 1924 by the Virginia legislature. You hear that? Not the executive department, not the judiciary, but the legislature. It institutionalized the one-drop rule. You're not listening to me. You're not listening to me. He was the leader of the Anglo-Saxon Clubs of America, a white supremacist, I repeat, a white supremacist. This was not based upon his nationality, his ethnicity, his genealogy, all right, but it was only based upon an aberration of the color of one's skin. At this time of the people that we're actually talking about, all right, what is the one drop rule? The one drop rule was a legal principle of racial classification. Now, did it say that in 1911 this was happening? Racial classification? It said that. The one drop rule was a legal principle of racial classification that was prominent in the 20th century United States. It asserted that any persons with even one ancestor, we're talking about genealogy, all right, not an aberration of a color of skin, but genealogy, ethnicity, okay? So they're not just was concerned about the color of skin, but they was also concerned about his genealogy, okay? And asserted that any person with even one ancestor's capacity, brother, this is where you got your interest in capacity from, your ancestors. So they said it asserted that any person with even one ancestor of black African ancestry, one drop of black blood, is considered black, Negro, or color in historical terms. Not legally, not lawfully, but in historical terms. If you got one drop of black blood in you, you are now deemed based upon not your ethnicity, not your genealogy, but an aberration of something that they created for you. Okay? They didn't want to call you white. They wanted to call you black, but you did fit the description at that time as white people. Why? Because when you look at the description as white people, it was not known to your genealogy or ethnicity. It was just dealing with a aberration of a color of a skin. And we know that in Anglo-Saxon time, there were, or European times, in Europe, there were people of darker hue. In Europe, in England, all right, very important to understand that. I'm not going to prove it. They're going to prove it for you. So we see the one drop rule. Now let's talk about the Racial Integrity Act. The Racial Integrity Act required that all birth and marriage certificates in Virginia to include the person's race as either white or colored. The act classified all non-whites, including Native Americans, as colored. I repeat. The Racial Integrity Act required that all birth certificates and marriage certificates in Virginia to include the person's race as either white or colored. The act classified all non-whites, including Native Americans, as colored. The act was part of a series of racial integrity laws enacted in Virginia to reinforce racial hierarchies, prohibit the mixing of races. Other statutes included the Public Assemblies Act of 1926, which required the racial segregation of all public meeting areas, and 1930 Act that defined any person with even a trace of sub-Saharan African ancestry as black, thus codifying the so-called one-drop rule. We're not talking about ethnicity, genealogy. We're talking about an aberration of the color of skin. Nothing more based upon the eyes of those who created this law, who passed this law, and those who uphold this law, based upon their understanding at that particular time, based upon how the status or legal standing of a person was. And in their eyes, as if you were black, colored, pink, purple, etc., you are not a citizen, meaning that you did not have the same interest and capacity that they had at that particular time. That makes sense to everyone? Okay, let's move forward. Let's look at the legal logic of this. We know that we were enslaved and we were emancipated, right? You know the dates. We were enslaved and we were in fact emancipated. We were not considered citizens yet. Okay? That didn't come to the 14th. That didn't come till uh, um, the Emancipation Proclamation. Okay? What was that? 1868, somewhere around there. All right. So the legal logic of whiteness in Inway Ahmad Hassan in a 1942 case. All right. So at this time we were still slaves. All right. Very important. We know that in the eyes of citizenship of the white people at this particular time, it was based upon an aberration of skin. Let's read it for ourselves. What is naturalization, first of all? Naturalization or naturalization is a legal act or process by which a non-national of a country acquires the nationality of that country after birth. So that means that you are now considered naturalized, which they call nationality, which we know means the same thing as coming up under the authority of those who use the eminent domain power called nationalization. Okay? All right, we understand the word nationalization is the same thing as eminent domain, which is to take private property for public use. Okay, and we understand that when they took us private property for public use, they did not compensate us, did not give us restitution, nor any reparation in regards to the eminent domain power that they used to do it. All right, very important. So through the 14th Amendment, they claimed to make us citizens by way of some type of naturalization process that made us nationals. Okay? We see that the word nationalization is a legal act and process by which a non-national of a country acquires nationality of that country after birth. Okay? We all see that, right? Now let's go to the Naturalization Act in which they used to do it. Write these things down. Once again, if you want me to come on your platform and teach, I'm open. Naturalization Act of 1790, in lieu of naturalization. The Naturalization Act of 1790 was the law of the United States Congress that set the first uniform rules for the granting of United States citizenship by naturalization. The law limited naturalization to free white persons of good character. This eliminated ambiguity on how to treat newcomers, given that free blacks, you hear that? Free blacks had been allowed citizenship at the state level in many states. So we're not even talking about the United States, we're talking about free citizenship on the state level, okay? In reading the Naturalization Act, the courts also associated whiteness with Christianity and Judaism, and thus sometimes excluded Muslim immigrants from citizenship by classifying them as Asians until the decision of Ex parte Mores. All right, we all see that. Congress modeled this after the Act of Plantation Act of 1740. Okay, so the Naturalization Act of 1790 was modeled after the Act of Parliament of 1740, okay, which predated. All right, what did it do? Okay. That Congress modeled the act of the Plantation Act of 1740 of the British Parliament that was officially titled An Act for Naturalizing Such Foreign Protestants and Others therein mentioned as are settled or shall settle in His Majesty's colonies in America, and used its provisions concerning time, oath of allegiance, process of swearing before a judge, etc. So this act of 1740 preceded the Naturalization Act of 1790, and the 1790 Act only had to do with what? The color of your skin, as known at that time, white. Okay? White. Very important to understand that. All right? Now, when we go back to the diagram or the flow chart, it says the legal logic of whiteness and Enway Ahmad Hassan. Okay? Because when we look at Enway Ahmad Hassan, Enway Ahmad Hassan was a case that dealt with how the courts how the courts establish who is in fact a citizen. Okay? Word versus why Kim Art was a case that dealt with the origin of where citizenship stemmed from. Okay? So very important. Anyway, Ahmad Hassan deals with what is a citizen, and United States 51 Kim Art deals with the origin of citizenship. All right? Which we're going to talk about today as well. All right? So let's first look at the case law. Anyway, Ahmad Hassan. To summarize the approach which must be followed in deciding whether a particular person applying for citizenship is a white person within the meaning of the statute, as interpreted by the Supreme Court, it is necessary to determine first the particular group or racial subdivision to which the individual belongs. That's the first test, brothers and sisters. Nationality. All right? Nationality, not what they meant based upon the Naturalization Act, based upon the operation of the color of skin, but the nationality. Okay? When you look at the origin of Anglo-Saxon, it all goes back to the origin of nationality, but even that can be questioned for those who claim to be of Anglo-Saxon descent, because we can see, based upon the Walter Plecker, he was of the Anglo-Saxon Club of America, which had nothing to do with the genealogy or ethnicity of a true Anglo-Saxon. It was just based upon the color of a skin. And he was also a member of what? The Ku Klux Klan. Okay? Who also identified with Anglo-Saxon. Okay? Which we'll talk about more in a second. So an individual who presents an aberration from the color of skin of the group of which he is in fact a member, such as a light-skinned Chinese or Japanese or a dark-skinned Anglo-Saxon, does not thereby acquire a different status under the act from other members of his group. Once again, we only make a reference to the color of skin. This is a hypothetical question that the judge threw out there. All right? A hypothetical question. The judge stated an individual who presents an aberration from the color of skin. One thing. That's totally different from the genealogy test or ethnicity test. Okay? So whether you had a light skin or dark skin, you still have to prove that you are in fact a member of that genetic group. Okay? Very important. So you profess to be somebody, but in fact you're not. We have a problem, Houston. So it said the individual who presents an aberration from the color of skin to the group of which he is a member, such as a light-skinned Chinese. They didn't even use the Arab, which was the the purpose of this case. They used a light-skinned Chinese. We know and understand that a Chinese is his nationality, and a light skin is the color of his skin. Or a Japanese, which we understand that his skin was light. All right, fitting the qualification of the intent of the Naturalization Act of 1790, which only had to do with light-skinned people, i.e., white people. But the court went further and says that a light-skinned Chinese or Japanese or a dark-skinned Anglo-Saxon does not thereby acquire a different status under the act of the other members of that group. Okay? Of course, when an individual applying for citizenship has a skin of a different color than is usual for the member of that group from which he claims to come, a strong burden of proof then rests upon him to show by the usual methods of proving genealogy that he is in fact a member of that group. Now, when we look at the Naturalization Act of 1790, there was not looking to prove the genealogy of a person, whether they were a dark-skinned Anglo-Saxon or a light-skinned Chinese or Japanese or Arab for that matter. What they're trying to prove, based upon this case, is the meaning and intentions of those who are classifying as citizens under the Naturalization Act of 1790, which had nothing to do with the first test. Okay? Very important. So what the judge is saying that, yeah, they were in fact Anglo-Saxons, hypothetically, that may identify with the group called Anglo-Saxons that are now identified as white people, all right, but not based upon the color of skin test, but based upon a genealogy test. So if that was in fact the case, that a dark-skinned Anglo-Saxon was in fact being classified in the court in present day, they would in fact be classified as white persons. Okay? That's what the judge was trying to say. You don't believe me? Let's check it out. The Legal Logic of Whiteness in Enway Ahmad Hassan, a 1942 case, which we just read. Okay? Is the applicant seeking citizenship as a free white person? Okay? Not based upon his ethnicity or genealogy or place of origin, but based upon the meaning of those at that particular time, how they identify citizenship, which is rooted in the Naturalization Act of 1790. Okay? Is the applicant seeking citizenship as a free white person? Yes. This is the decision that Judge Tuttle had to make in that particular case. So for that, we must go to step one. The meaning of how they identified citizenship at that time this case came about. All right? The courts rejected the scientific definition, all right, of the origin of the parties, okay, in regards to citizenship. Court rejected it. As you can see here, we see Ahmad Hassan, a light-skinned Arab, right? You see Ahmad Hassan as a light-skinned Arab, and then you see an exhibit of a dark-skinned Anglo-Saxon. Okay? Now, Ahmad Hassan automatically, as an Arab, falls under the nationality as an Arabian. Okay? As a Muslim. The court gave an example of an Anglo-Saxon that was dark-skinned. It didn't say light-skinned. It said dark-skinned, but we know based upon Walter Plecker claimed to be a white-skinned Anglo-Saxon, but the judge didn't say white-skinned Anglo-Saxon. He said dark-skinned Anglo-Saxon. Let's go back to Walter Plecker. All right. He was the leader of the Anglo-Saxon Clubs of America, a white supremacist. So when you look at the Anglo-Saxon clubs of America or any club in America, they're not making any connection to the genealogy or ethnicity of those who met the standard or the test in regards to true nationality. Okay? Very important to understand that. What they're doing is practicing eugenics. All right? Very important. All right. So now we see Walter Plecker was an Anglo-Saxon who was a member of the Anglo-Saxon clubs of America based upon the color of skin. Had nothing to do with the genealogy or ethnicity of the people who were in fact Anglo-Saxon. And we read based upon the 1911 Encyclopedia Britannica that Berbers had more connection with Anglo-Saxon than white people did. All right. Very important to understand that because of their interest in land, agriculture. All right. Customary laws. Very important to understand that, all right? Not the laws of those who practice eminent domain, which was the laws that were used by the founding fathers, who all fell up under the categories of what they call white people. All right? Very, very important for you to comprehend that. Anglo-Saxon club. What is that? Anglo-Saxon Clubs of America. What is that? The Anglo-Saxon Clubs of America was a white supremacist political organization which was active in the United States in the 1920s and lobbied in favor of all if I'm pronouncing wrong, please forgive me, anti-miscegenation laws and against immigration from outside of Northern Europe. That's very important to understand that Walter Plecker was a white supremacist who identified with the Anglo-Saxon groups who only identify Anglo-Saxon based upon the color of skin, but not the origin of the Anglo-Saxons based upon genetic tests as stated in what we call Imre Amar-Hassan, which Imre Amar-Hassan could not measure up to a white person in the meaning of the Restitution Act of 1790, nor could he fit that description going back to the genealogy test in regards to ethnicity, all right? Because he was, in fact, an Arab. Let's move forward. So Judge Tuttle had to decide if Amar-Hassan was considered a citizen in the eyes of how the founding fathers saw citizenship as established under the Restitution Act of 1790. The court rejected any evidence based upon scientific proof, i.e. genealogy, nationality, etc. All right, courts rejected that. Step 2. Step 2. Apply common understanding test. Would the average American consider this person white? Okay. No. Under the modern understanding of the Restitution Act of 1790 in regards to Imre Amar-Hassan's argument, he would not be classified as a citizen. Why? Because in the meaning of the Restitution Act, it only can be identified with the aberration of a color of skin. All right? No genealogy test, no ethnicity test, just the color of your skin. So when you read Imre Amar-Hassan, and being that Judge Tuttle gave a hypothetical analysis in regards to the type of citizenship that was different from that as interpreted by the founding fathers, he went into the genealogy test, which was the first test to prove that you are in fact a member of that group. And he gave 3 specific groups, not just Imre Amar-Hassan, but white themselves as well as white people. And he said the dark-skinned Anglo-Saxon had the first proof that he was in fact connected to the Anglo-Saxon based upon genealogy, okay, and not the meaning of those who and interpreted not the meaning of those as interpreted in the Restitution Act of 1790, which only had to do with the application of a color of skin. So in that essence, Enwei Hassan will not be classified as a white person. But guess what? We as black people, pardon, some as Anglo-Saxons was, even though we had dark skin. All right? Step 2. Apply common understanding test. Was the average American consider this person white? No, because we have to take the group test. All right? We have to take the group test. The group test, that means that Europeans and Anglo-Saxons, in lieu of ancestry, have a common connection, okay? Have a common ancestry, all right? Even if you were light-skinned or dark-skinned, if you were Anglo-Saxon, it had nothing to do with the meaning of the Restitution Act in regards to the operation of the color of skin. It all had to do with the connection you had dealing with ancestry, genealogy, going back to the Anglo-Saxon, which is still suspect based upon that term as being used, okay? And as we see in that case law, and we understand that Enwei Hassan had nothing to do with the origin of citizenship, but how citizenship will be identified in regards to that case, which it clearly pointed out that there's two tests, one based upon the operation of color of skin and one based upon the genealogy and ethnicity of the nationality, okay? So it said whether you were Anglo-Saxon from the nationality perspective or genealogy perspective or ethnicity, even if your skin was dark-skinned, you would be considered what? A white person, okay? So if you're a European of Anglo-Saxon ancestry, legally white in the eyes of law, even if your skin was dark, you would classify as a citizen here in North America. All right? If you were not identified in the meaning of how they deemed it in 1790 in regards to color of skin, then you were not, in fact, a white person. You were considered an Arab. Why? Because you are not of any European descent as classified on the Anglo-Saxon ancestry. You are an Arab, and Arabs, Indian, or Asians were not classified as white people. Okay? Hope we all understand that. Let's look at this through a lesson plan. Topic: Racial prerequisite case in Enwei Hassan, a 1942 case, at a time when we were still slaves. Once again, if you got any platforms out there that want these lessons, please reach out to me. All right? My number is 732-822-1329. Once again, 732-822-1329. You can give me a call. We can schedule a time to meet and greet. Okay? As well as like, share, subscribe, donate free and common sockets. All right? Because it's all needed for me to continue my work. Lesson plan. There's genealogy of whiteness. Okay? And we're going to use Enwei Hassan case to prove this. Now, we know Enwei Hassan approves who in fact could be a citizen, but Joachim Ark goes back to the origin of citizenship. So let's just touch on that real quick. United States versus Joachim Ark. Let's just touch on that real quick. There's definitely going to be a part 3 on this as well. Joachim Ark. Where is that at? Right here. Excuse me. (1898) case. How do y'all claiming that the Constitution protects your rights as a citizen? Well, listen what the Constitution says. The Constitution nowhere defines the meaning of these words, either by, let me go a little further up. The Constitution of the United States, as originally adopted, used the word citizen of the United States and natural born citizens of the United States. By the original Constitution, every representative in Congress is required to have been 7 years a citizen of the United States. Now, we're not talking about natural people, we're talking about entities because they are a corporate body of politics. They were known as what they call your freeholders. Guess what? They're not your freeholders. You are. 1 second, hold that thought. Okay. United States versus Kim Art. Constitution of the United States, as originally adopted, used the word citizen of the United States and natural born citizen of the United States. By the original Constitution, every representative in Congress is required to have been 7 years a citizen of the United States. Now, we already know what they meant by citizen in the Naturalization Act of 1790, and that dealt with the aberration of the color skin as white people. Okay, but we see when Judge Toto made reference of not white skin, but dark skin Anglo-Saxon, he referenced that in regards to first the genealogy and then the color, the meaning in regards to the Naturalization Act of 1790. We see here in the United States versus Ron Kim Art that the United States nowhere defines what a citizen is. Okay, let's prove it. The Constitution nowhere defines the meaning of these words, either by way of inclusion or of exclusion, except insofar as this is done by the affirmative declaration that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Remember, at this time, you now were emancipated and you became a citizen, but not in the meaning of an ethnicity genealogy test, but in the meaning of the Naturalization Act or any other act that passed that had nothing to do with who you truly are. All right. To that, you must look to other sources. It's in this, as in other respects, it must be interpreted in light of what? The common law, the principle and history of which were familiarly familiarly known to the framers of the Constitution. This is why you were not allowed to read and write, because they knew your capacity. They knew your interests. They knew that you had a right to the land because it belongs to you, all right, because of your connection to the land. Let's continue. The language of the Constitution that has been well said cannot be understood without reference to the common law. Okay? We must understand this, y'all. We must understand that. Let's check it out. In Smith versus Alabama, Mr. Justice Matthew delivered the judgment of the court, said, there is no common law of the United States in the sense of a national customary law, distinct from the common law of England as adopted by the several states, each for itself, applied as its local law, and subject to such alteration as may be provided by its own statutes. You hear that? Statutes, okay? This is the living word of your ancestors, okay? This is the decentralization of the secularized law that were once religious, which we call ecclesiastical or canon law. Okay, it now had become secular law through what we call modern day statutes protected by the common law, which is present, which we're reading right now. There's, however, one clear exception to the statement that there is no national common law. The interpretation of the Constitution of the United States is necessarily influenced by the fact that its provisions are framed in the language of the English common law and ought to be read in light of its history. Did you hear that? So if you have anything to do with this land, you better know the history of the English people, okay? Misclassified as white people, Anglo-Saxons, and any other identity that you can come up with. But we don't throw the baby out with the bathwater. We must sift through it like a fine-tooth comb. 2. The fundamental principles of the common law with regards to English nationality was birthed within its allegiance, also called legality, obedience, faith, or power of who? The king. The principles embrace all persons born within the king's allegiance and subject to his protection. So if they're saying this in 1898 in regards to your protection, all right, this is your interest and capacity that's protected via case law, okay? Not just case law, statutory law. We just read it. Hold that thought. Okay, so as we can see, brothers and sisters, there is no common law of the United States in the sense of a national customary law, distinct from the common law of England, as adopted by the several states, each for itself, applies as to the local laws, and is subject to such alteration as may be provided by its own statutes. Did you hear that? So if you're looking for a declaratory and injunctive relief, it must be based upon the statute, because that is the ancient language of God when it was ecclesiastical or canon law, now decentralized and secularized into modern day law, okay, called your modern day statutes. Did you hear that? Your modern day statutes. Let's get it. Lesson plan. Genealogy of the whiteness. Topic. Racial prerequisite cases in Enway Ahmad Hassan, 1942 case. Objective. To understand how the United States legal system defines white through genealogy rather than physical appearance. Did you hear that, y'all? Through physical appearance. 1. The hook. The dark skin paradox. We know what paradox means, right? We know what it means, right? So if you know what it means, each and every one of you right now who are watching this lesson, ask yourself this question. If a person has dark brown skin, are they legally white? Ask yourself that, brothers and sisters. If a person that has dark brown skin, not use the word black or colored, just dark brown skin, are they legally white according to Inway Ahmad Hassan? We ain't even talking about the origin of citizenship. We're talking about how it applies or what is citizenship, okay? Or who classifies this as citizen. All right. I'm asking you the question now. If you have dark brown skin, are you in the eyes, not historically, not religiously, not philosophical, but in the eyes of the law, are you classified as legally white in 1942? Guess what, brothers and sisters? Yes, you are. Yes. If they are what? Anglo-Saxon. Why? Because that was the hypothetical question that Judge Tuttle put up in the box. This is called statutory analysis. Okay? Statutory analysis, the plain meaning rule. Okay? It's the group test. Not just your individual identity, but do you classify as the same as other members of your group? And you cannot do that by color of skin, because when you're dealing with Anglo-Saxon, you're talking about a history going all the way back to European contact, and that's the answer it stems from. And in the eyes of the law, that's who you are in the present day, based upon how the law is now being applied. And yes, you will legally be classified as white, even if you're dark-skinned, because we know that they were classifying as light-skinned people, but still trying to make the connection to Anglo-Saxon. They said Walter Plecker claimed to be an Anglo-Saxon. The people known as WASP claim to be Anglo-Saxon, but that's only based upon a color of skin and not based upon a genealogy test. All right, we understand that we do a genealogy test. We know that they have more in common, like the Berbers, okay? Because the Berbers and the Anglo-Saxon all had connections to the land. And the way they preserved the land was through assemblies that dealt with liberty, freedom, customs. Okay, this is called folk right, or until it was called folk right until it became book land. Okay, very, very important to understand that. So if you have any European ancestry, and yes we do, because we know that the indigenous people of Europe, before they were invaded by the Arabs, all right, through the Iberian conquest. Before that, you had the conquest of the Maghreb. Before that, you had the conquest of the what we call the land of Canaan. All this was done by who? Arabs. Okay, we already understand their customs. All right, they were warlike, centralized hierarchies. All right, they was not concerned about establishing a more centralized government like the Anglo-Saxons. Very, very important to understand that. Let's continue. So you ask yourself the question, if you have dark skin or brown skin, in the eyes of the law today, are you classified as a white person? If you're not saying you're Anglo-Saxon, then no, you will not classify as a white person, because we know Anglo-Saxons has a history that goes back to what we call the European continent. All right? Very important. All right? And Judge Tuttle said that those Anglo-Saxons who had a history going stemming back from the European continent apparently must have been dark-skinned, because he used the word dark-skinned versus the term light-skinned. All right? Very important. And he classified 3 groups of people: Caucasians, Arabs, and Chinese. Okay? So which one do you classify as? This lesson explores how judges use the dark-skinned Anglo-Saxon as a legal tool to exclude non-Europeans from citizenship. Did you hear that? Did you hear that? Let's see how they did that. Point 2, case study. In Ray Ahmad Hassan, a 1942 case, the petitioner was Ahmad Hassan, a Yemeni immigrant with dark brown skin. Okay? Not white skin, but dark brown skin. He was trying to classify as what? A American citizen under the Naturalization Act of 1790 as a light-skinned person. He didn't even classify as that. All right, Judge Toto said that even if you use that test, you cannot classify, and if you use the genealogy test, you cannot classify because he said a dark-skinned Anglo-Saxon, which is no more different than a dark-skinned Anglo-Saxon genealogy qualifying as a light-skinned or white-skinned person based upon that act. Either one, you still classify as a citizen. What you lack is a connection to your genealogy as a white person. Okay? Very important. So here's the conflict. The petitioner, Ahmad Hassan, was a Yemeni immigrant with dark brown skin. The goal was to be naturalized as a white person, a requirement for citizenship at that time. You hear that? The conflict. Hassan argued he was ethnologically a Caucasian. The court argued he was not white in the eyes of the common man. Now, you know what a common man is, right? How many of you know what a common man is? Look that term up. Don't forget it. Write it down. Look up what a common man is. So the conflict came when Hassan claimed to be a Caucasian, like those who call themselves Caucasians identify as what we call white people. Okay? And not even going into a genealogy test, Walter Plecker or any of the founding fathers would not classify as a white person if it had to be construed to a genealogy test, because that's not what they used in Europe prior to that. All right, you have to go back into the genealogy or ethnicity of a person. Okay. Key legal concept: group test. Key legal concept: the group test explains Justice Total ruling on how races was determined. Individual versus group. The court ruled that race is not about how you look, but about the group you belong to. Once again, I repeat. Imre Ahmad Hassan in 1942 case did not rule on how the race parts of. The court did not rule on based upon how you look, but about the group you belong to in regards to a genealogy test. And when the hypothetical question was put out based upon a genealogy test, the court clearly pointed out that the Anglo-Saxons were of dark skin. Even though it was hypothetical, he said they were dark skinned, not like those who were light skinned and members of the Anglo-Saxon club, such as Walter Plecker, or those who are called white Anglo-Saxon Protestants. Okay, very important. So, individual versus group. The court ruled that races is not about how you look, but about the group you belong to. Let's look at the Anglo-Saxon example. The Anglo-Saxon example. The judge, i.e. Judge Tuttle, the judge used a hypothetical dark-skinned Anglo-Saxon to prove his point. Even if an Anglo-Saxon had dark skin, they remain legally white because their genealogy ancestry is what? European. Y'all not listening to me. You are not listening to me. We already know what Juan Kim Ark said about the origin of citizenship. It must be construed to the common law in light of its history. Even though the history of the common law is English, which goes back to those who are identified as Anglo-Saxon, which in fact is a monomer as well. Okay, so we see Anglo-Saxon. The judge used this example, which was a hypothetical example, and stated that dark-skinned Anglo-Saxons to prove his point that in regards to proving that you're in fact a citizen from the first test was through genealogy, and the second test was based upon the Naturalization Act and the meaning of it based upon those who were considered to be the common man. Okay? So the judge used a hypothetical dark-skinned Anglo-Saxon to prove his point. Even if an Anglo-Saxon had dark skin, which you call now black or colored, they remain legally white because their genealogy ancestry was European, just like Juan Kim Ark said. The aberration rule. The court called dark skin or white person a physical aberration, a glitch that didn't change their legal status. Once again, the aberration rule. The court called dark skin or white person a physical aberration, a glitch that did not change their legal status. The only way your status can change is to go back to your genealogy. All right. Interest and capacity to your people. All right. 4. Discussing genealogy as a gatekeeper. Y'all not listening. My phone should be blowing up right now. Discussion. Genealogy as a gatekeeper. Analyzed why the court shifted from skin color to genealogy. Exclusions. By focusing on ancestry, the court could disqualify light-skinned people from Asia or the Middle East, like Bhagat Singh thing, which is another case, which I'm not going to reference today, while protecting the status of dark-complexioned Europeans. You hear that? Not white-complexioned Europeans, but dark-skinned complexioned Europeans. Did you hear that, brothers and sisters? Social construction. Discusses how this shows that whiteness was a shifting legal definition designed to keep certain groups out of power. Did you hear that? Did you hear that? Think on that for a little second. Hold on, let me get me some something to wet my whistle. Comparison. Frederick Douglass. You know who Frederick Douglass was. He was the county recorders. All right? Comparison. Frederick Douglass rhetoric. Compare the court's view to Frederick Douglass. Douglass often pointed to his own mixed white ancestry to mock the logic of these laws, such as the laws passed in regards to those denoting to the color of skin. He argued that the Anglo-Saxon spirit was about love for liberty, something he felt black Americans possessed more than the people trying to oppress them. We understand that how could you call yourself an Anglo-Saxon when we understand Anglo-Saxon had more in common with black people in modern day as those who were Anglo-Saxon in the ancient day, because we know that the Anglo-Saxons were more kin to what we call a liberty-based custom or tradition system, right? Because we understand that the same thing they faced back then, we face today, invasion, okay, to what? The eminent domain power of foreigners. He argued that the Anglo-Saxon spirit was not the people, but the spirit was about the love for liberty, something he felt that we had more in common than those who claimed to be the Anglo-Saxons based upon their connection, okay? So you must understand that he knew way back then about our legacy. Conclusion, the legacy. The genealogical test eventually failed because it was inconsistent. By 1952, the United States removed all racial requirements for citizenship, admitting that skin color and ancestry were not valid measures of a person's fitness to be an American in the case of Imre Hassan. Why? Because they didn't give a damn about your nationality. They didn't give a damn about your ethnicity. They didn't give a damn about your genetics. All it cared about is that you fit into the classification of what they deem as citizen, i.e. white person, okay? And so if you are if your ancestry and genealogy classify as European, which is based upon those who were ancestors go back to Europe, then according to the law itself, you will still be classified as a citizen, i.e., identified as a white person. This is why they passed the 14th Amendment, because they knew we were, in fact, the white people. Okay, under that new classification, which puts you in what they call a civil status, but not a political status. For that, you need that capacity and interest return, which I'm returning to you by you getting this understanding by becoming a statutory entity, baptized by way of the living water that was preserved in the living vessel, i.e., the corporation soul. All right? Let's look at Judge Tuttle reasoning. Judge Tuttle was not necessarily arguing that specific subgroups of dark-skinned Anglo-Saxons existed as a separate category. Instead, he used the phrase as a legal hypothetical to establish that genealogy, not skin color, was the ultimate decider of a person's legal race. Did you hear that? So it was left up for us to decide based upon the hypothetical question that Judge Tuttle presented, if we can classify ourselves genetically to the Anglo-Saxon race and not based upon that of a color skin like the white people did. All right? And we know in the 1911 Encyclopedia Britannica did that because it showed that we had more in common with the land based upon our customs, which is based upon maintaining the continuity of that possession, which is what we call liberty or freedom. Judge's reasoning. Bear with me. Okay. The judge's reasoning. Judge Tuttle argued that the law required a racial rather than an individual test. To explain this, he used two opposite examples. The dark-skinned Anglo-Saxon. Once again, the judge's reasoning. Judge Tuttle argued that the law required a racial rather than an individual test. To explain this, he used two opposite examples. One, the dark-skinned Anglo-Saxon. He stated that if a person belonged to the Anglo-Saxon group, which the law already accepted as white, they would remain legally white even if their individual skin was dark. Once again, I repeat. Judge Tuttle stated in his analogy in regards to the hypothetical question that he threw out there in regards to the proofs of citizenship, he stated that the dark-skinned Anglo-Saxon, he said that if a person belonged to the Anglo-Saxon group, which the law already accepted as white in modern day, they would remain legally white even if their individual skin was dark. He viewed dark skin in this specific case as a physical aberration that did not change their group status. So even though you had dark skin, it didn't care about that. It's based upon your genealogy, race, ethnicity. That was needed to be proven. That was needed to be proven because that's where your interest capacity comes from. Okay? Then he also used the light-skinned Chinese. Conversely, he argued that a person with very light skin who belonged to Chinese group would still be legally non-white because their group was not classified as white based upon the meaning of those who created that distinction of white based upon the Naturalization Act, which had nothing to do with European ancestry going back to Europe that identified with the Anglo-Saxons based upon genealogy, such as those being dark-skinned. Okay? Very important to understand this madness. Why genealogy matters. The judge used the logic to deny Ahmad Hassan's petition for citizenship, even though Hassan lawyers argued that Arab was ethnologically Caucasian. The judge ruled that 1. Group identification first. An applicant must first prove which racial subdivision they belong to using the usual methods of proving what? Genealogy. How many of you have done that? 2. The common man standard. Once the group has identified, the court decided if their entire group was what the common man in 1790 would have considered white. And as we've proven, that Anglo-Saxons were considered white because based upon their origin going back to Europe in lieu of a genealogy test. So if they classify as white going back to Europe as the genealogy test, then the meaning still classified as white under the modern test, meeting the classification of the founding fathers who did not meet the test going back or based upon genealogy. Okay? So this hypothetical question put forth by Judge Total was a bloodline gatekeeper. Okay? It was a bloodline gatekeeper. In short, the judge used the idea of a dark-skinned Anglo-Saxon to prove that bloodline was the gatekeeper. If your genealogy was from a white group, your skin color didn't matter. If your genealogy was from a non-white group, your skin color couldn't save you. You hear that, brothers and sisters? Once again, in short, judges used the idea of a dark-skinned Anglo-Saxon to prove that bloodline was the gatekeeper. If your genealogy was from a white group, your skin color didn't matter. If your genealogy was from a non-white group, your skin color couldn't save you. In the legal logic of Enway Ahmad Hassan, 1942 case, the dark-skinned Anglo-Saxon was a shield used to ensure that Southern and Eastern Europeans remain protected and legally classified as white regardless of their skin tone or tan. Did you hear that? The specific groups protected by this ancestry over appearance gatekeeping included what? Southern Europeans, which were Italians and Greeks. These groups were primarily concerned of the courts. Many immigrants from Sicily, southern Italy, and Greece had darker complexion that did not fit the Nordic ideal of whiteness. Did you hear that? Did y'all hear that? Skin was still white because of their genealogy. The court ensured that Italians and Greeks who were recognized as Europeans remained legally white despite their olive or dark skin. Did y'all hear that? Did you hear that? My phone should be ringing like I said. 732-822-1329. If you want to do a lecture or have me come up on your channel, please reach out to me. Eastern European, Slavs, and Ashkenazi Jews. Hold that thought. Okay. Now we have Eastern European, Slavs, and Ashkenazi. I think we had an interruption. Yeah. Where were we? Okay. Dark skin complexion, Anglo-Saxon. The judge specifically wanted to protect white Americans of British descent who happen to have dark hair, dark eyes, or skin that tan deeply. He classified these physical traits as mere aberrations that did not change their superior legal status. The legal result. This gatekeeper logic created a racial hierarchy where European ancestry, i.e., genealogy, was the only valid key to the gate of citizenship. It allowed the court to reject Ahmad Hassan in Arab and Bhagat Singh Ding in Indian by claiming they were not white in the eyes of what? The common man, even if their skin was lighter than some dark-skinned Europeans. In the 1920s and 30s, the United States Supreme Court deliberately moved away from the scientific racial theories like Caucasian because those theories were beginning to include people the court wanted to exclude. Instead, they invented the common man test, which allowed them to ignore biology in favor of some prejudice. Did you hear that? Conflict, science versus social custom. In the early 20th century, anthropologists classified many groups from India and Middle East and North Africa as Caucasians. This created a massive problem for a legal system that restricted citizenship to white persons. The scientific argument, petitioners like Bhagat Singh Ding argued that the high caste Indians that were Aryans and therefore Caucasians, making them scientifically white. The court pivoted in the Thing case, and they stated that in 1923 ruling, Judge George Sutherland, Justice George Sutherland famously admitted that while Thing might be a Caucasian by science, he was not white by the understanding of what? The common man. So we must understand the common man's mind. Okay? The rejection of expert knowledge. The court explicitly stated that the words of the Naturalization Act of 1790 were written in the common speech and should not be interpreted by scientific definitions that the original writers wouldn't have known. Did you hear that? Did you hear that? This is crazy. Now, we know the 1911 Encyclopedia was a book created through the Enlightenment era, which means of science, okay? So if the age of science was not there prior to their understanding, then that means that they had no origin of understanding other than those who understood, all right? So it said the naturalization, which were written in the common speech and should not be interpreted by scientific definition that the original writers wouldn't have known. So the original writers, in regards to the Naturalization Act, wouldn't know a damn thing about genealogy, all right, ethnicity. How the common man test contradicts the science. You can't make this stuff up. The court used this test as a moving goalpost to ensure that whiteness remained a gatekeeper for European power. When science supported exclusion in cases involving East Asians, Ozawa versus the United States, the court used science to say that they were mongoloid and therefore not white. 2. When science supported inclusion, when people from India, i.e. the Singh Ding case, or Yemen and Ray Hassan, used science to prove they were Caucasians, the court suddenly declared that science was what? Irrelevant. Okay? It was irrelevant. 3. The common man as the judge. By using the common man who was implicitly a white Christian American of European descent, the court can legally say, we don't care what the scientific say. If an average person on the street doesn't think you look like us, you can't be a citizen. Once again, they said we do not care what the scientists say. If the average person on the street doesn't think you look like us, you can't be a citizen. All right, we see that clearly in the Naturalization Act of 1790. Okay. In closing, the common man standard was the ultimate tool for gatekeeping. It allowed the law to ignore the dark skin of a European while using the dark skin of an Arab or Indian as a reason for exclusion. Frederick Douglass died in 1895, decades before the Ding and Hassan case, but his writings directly attacked the flexible logic that judges eventually used to exclude people from citizenship. Did you hear that? Douglass recognized Douglass recognized Douglass recognized that racial definitions were not based on stable science, but were a social and legal construct, a genuine American feeling that would shift whenever it suited those in power. How Douglass predicts the court's logic. The wish is the father to the thought. Douglass argued that white supremacy created the science, not the other way around. He noted that when experts claimed ancient Egyptians weren't related to Africans, they weren't being scientific. They were just trying to deny black people any claim to civilization. This perfectly predicted the Things case, where the court admitted science said one thing, but their wish for a specific social order dictated another. The fall of Anglo-Saxon period. The fraud of Anglo-Saxon superiority. Douglass often mocked the idea of a pure Anglo-Saxon race. He pointed out that the English were themselves a mixed race of Celtic, Saxon, Normans, and others. He saw Anglo-Saxonism as a political brand rather than a biological reality. The exact brand that Judge Tuttle used in Imre Ahmad to protect dark Europeans while excluding dark Arabs. You hear that? The common man adds prejudice. Point 3. Douglass argued that racial prejudice in America was an educated habit, not a natural one. He knew that if the common man was the judge, the verdict would always be based on whatever bias was currently popular. In 1854 speech, The Claims of a Negro Ethnologically Considered, he argued that pride and selfishness was the real author of racial categories. By the time the courts were using the dark-skinned Anglo-Saxon as a gatekeeper, they were proving exactly what Douglass had warned, that the definition of white or Anglo-Saxon will always be the stretch or strunk to keep the gate closed to anyone the majority found un-American. Once again, it said that. Let me just go back here. By the time the courts were using the dark-skinned Anglo-Saxon as a gatekeeper, they were proving exactly what Douglass had warned, that the definition of white or Anglo-Saxon White or Anglo-Saxon will always be stretched or shrunk to keep the gate closed to anyone, the majority found un-American. In Virginia, the Racial Integrity Act of 1924 turned the common man test into a strict bureaucratic weapon by codifying the one-drop rule. This law was the ultimate expression of the genealogy as gatekeeper logic you've been exploring. How the law redefines genealogy. While the federal courts used the dark-skinned Anglo-Saxons to keep the gate open for Europeans, Virginia used a one drop to slam the gate shut on anyone with any non-white ancestry. Did you hear that, y'all? We are the key. The one-drop definition, the act legally defined a white person as someone with no traces whatsoever of any blood other than that of Caucasian. Invisible blackness. This created the legal concept of indivisible blackness, where a person who looked perfectly white, an individual aberration, was legally reclassified as color if a single African ancestor was found in their family tree. The Pocahontas exception. The Pocahontas exception is a bizarre twist of flexible logic. Virginia elites carved out an exception for themselves because many prominent white families claimed descended from who? Pocahontas. The law allowed people with up to 1/16 Native American blood to still be called white as long as they had no other non-white ancestry. The paper genocide of Native Americans. The act most aggressive gatekeeper was Walter Plecker, the Registrar of Bureau of Vital Statistics. Erasing identity, Plecker believed there were no real Indians left in Virginia, only mixed race people trying to pass off as white. Changing records. He systematically changed birth and marriage records, reclassifying entire tribes like the Pamunkey and Chickahominy, if I'm pronouncing wrong, please forgive me, as color. This paper genocide effectively erased their legal existence for decades to maintain a strict white-black binary, the result of a two-race system. The law ensured that there were only two categories, white or colored. By using genealogy as a strict filter, the state could what? 1. Prevent intermarriage. It made it a felony for a white person to marry anyone with even one drop of non-white blood. 2. Solidify power and ensure that whiteness remained a small, exclusive club that was traceable and enforceable through paperwork, hence Anglo-Saxon clubs of America. This law stood for over 40 years until it was finally struck down by the Supreme Court in 1967 by Loving versus Virginia. In Virginia, Walter Plecker used lists of specific family names to enforce Racial Integrity Act and carry out what historians call a paper genocide against Native Americans. Okay? Against Native Americans. Plecker. Come on. Okay. So to prevent this passage, Plecker compiled and distributed lists of surnames to local registrars, hospitals, and schools. The target: if person's last name appeared on his list, they were to be automatically reclassified as colored or Negroes on all births, marriages, and death certificates, regardless of how they look or identify. impact on the family. Entire lineages were erased from the public records in a single generation. This made it nearly impossible for Virginia tribes such as the Monacan, Pamunkey, and Chickahominy to prove the continual existence required for federal recognition later in the 20th century. Okay, so as you can see, what Walter Plecker did, and as we see in Ray Mahassan, in regards to proving the fact that you are a citizen, you must understand that the only way you can do that is through doing a genealogy test in regards to your true identity, which is what? Berbers, okay? Berbers. We must understand how important this lecture is. Once again, like, share, subscribe, donate free and common sockets. If you want me to do a lecture on your podcast, please reach out to me by leaving a comment in the comment box, or reach out to me by way of cell phone 732-822-1329, and I will definitely look forward to complying with that. So once again, part 3 will be produced within a couple of days to part 1 and 2, and I hope you enjoyed it. And with that, I'm going to greet you as I always greet you, as in that care and the love of our ancestors. Keep echoing the peaceful. With that, I say